Good morning, everyone. This is the second day of the meeting of the National Labor Relations Board. I'm still Mark Gaston Pierce, the chairman. And to my right are board members Kent Hirazawa and Phil Miskamara, and to my left are board members Harry Johnson and Nancy Schiffer. As was stated yesterday, the purpose of this meeting is to hear from question individual presenters. This is not a group presentation by any means. We're grouping folks there for administrative convenience. Although presenters are encouraged to reply to the extensive prior written commentary submitted to this rulemaking, this meeting is not a forum for group discussion among the presenters. So if there is a question that we ask, we're going to be trying to focus it on the individual rather than the group. And speakers should address the board and not other speakers. Housekeeping is that you keep your badges. Same story. This is a very exclusive nightclub. If you lose your badges, you might not be able to get in. If you go out for lunch, make sure you have your badges with you to come back in, and then at the end of the day, make sure and trade your badges in for your driver's license so that you'll be able to get on the plane. You should note that there has been adjustments to the schedule, so anybody who is working from the old schedule, you might be advised to pick up some of the new schedules that are available outside. The first seating, and this is the first grouping. This is a topic area that involves 5 seatings, so we're going to have a lot of testimony in that regard. I strongly encourage those people following to make adjustments to their presentations once points have been made that are very similar or possibly exactly like the point that you're going to make, so that we can reduce repetition. We hate to remind people of that if it gets too repetitive, but we will. That all being said, this is all I'm going to say. We're going to no, I'm about to say something else. We're going to have lunch at 12:30, closer to 1 o'clock, and we're going to have a short break at approximately 11 or 11:30. Okay. The topical area is the election date. Please describe the standard to be applied for scheduling an election. The proposed rule stated that the regional director should select an election date which is as soon as practicable. If you disagree with the standard, please describe the standard you would apply. Specify whether you think the rule should include a minimum or maximum time between the filing of the petition and the election. And if so, how long this time should be. Also address whether the proposed rules adequately protect free speech interests. If you believe they do not, please so state, and state specifically how the proposal can be adapted to adequately address the matter. The first seating, we have Joseph Torres, Brian Petruska, Elizabeth Melito, Edgardo Villanueva, and Glenn Rothner. Welcome, everybody. Thank you. Mr. Torres, you can proceed.
Thank you, Chairman Pierce. Again, my name is Joseph Torres. I'm a partner in the law firm of Winston & Strawn based in their Chicago office. Chairman Pierce, members of the board, thank you again for the opportunity to address you regarding the proposed election rule changes. As you noted, we were asked to address two specific issues concerning the timing of election and the effect of that on the free speech interests guaranteed by the National Labor Relations Act. And I would submit that the as soon as practicable standard in and of itself doesn't do much to inform a practitioner as to what they should expect. What matters is ultimately what that standard evolves into in terms of an actual time frame for conducting elections. And I submit that a more appropriate measure of that time period should be the existing median times that the vast majority of NLRB elections are resolved. It represents a benchmark that has been developed through collective experience. And to that extent, I believe it provides a reasonable degree of certainty for interested parties. You can see what has happened in the past, you can apply it to your situation, and develop some reasonable expectations for your clients as to how this process will play out. With many of these clients, as I'm sure you've heard over the last day, have little or no experience with the National Labor Relations Act, and so bringing certainty to the process, in my opinion, promotes the best policy for this board to pursue. To the extent that the proposed as soon as practicable standard is intended to refer to the 10 to 21 day time period that is contemplated by the notice of proposed rules, I believe it proceeds from a faulty assumption that the current median times, which are well documented, require some wholesale revision. I believe that the sort of extreme or isolated examples of elections that have exceeded the median times by substantial amounts relative to the overall number of elections that this board processes in every year, its own statistics make clear that the vast majority of election cases are resolved in an efficient and expeditious process. And any alleged need to shoehorn all election cases into an unnaturally short time period lacks any generally acceptable empirical support. In my experience advising clients that are small, that are large, the current median times, as I said, provide some reasonable reference point for individuals as to the timing and expected developments of an election campaign. And I believe that establishing guidelines to inform an as soon as practicable standard requires you to look at the timing of elections in various sizes and industries, geographic locations, and circumstances. And that based upon that experience is a sound basis for policy development. In contrast, establishing significantly shorter, generally applicable time periods based on an atypical minority elections, I would submit, is not. I would note that the board can more precisely address any specific issues that might warrant deviation from those median times by looking at data that could identify the factors that may be causing delay in some cases, seeking input from relevant constituencies as to how such factors could be addressed to reduce delay in cases when that occurs, and identifying a consensus-based solution, which I would suggest the median time periods represent. They balance employee Section 7 rights, the need for reasonably prompt resolution of election issues, the rights of labor employees and labor organizations to meaningfully advocate their views. And I think that takes us to the next point. For employers and employees and labor organizations to have a meaningful ability to express their views concerning unionization and organizing campaigns, I think it's important that the time periods that are set for an as soon as practicable standard allow not only for communication itself, but education as to what we're actually talking about. I believe, again, that statutory rights such as those embodied in Section 8C must also include some reasonable opportunity for expression in order for the statutory right to have any meaningful benefit. And to the extent that the current median timeframes allow for reasonable processing of the vast majority of elections, I would submit that employers and employees should be able to engage during those time periods in some reasonable amount of education and communication regarding the election. It is a balance to be struck, recognizing that we're not dealing with absolutes in terms of what is the only time period for holding an election. I think that the circumstances that various elections present themselves should allow for variation, and that the median time frames show that that generally happens in a fairly efficient and effective process. And when there are circumstances that the board in its experience identifies that requires some adjustment, it would benefit, a solution would benefit from a more precise assessment of the factors that may be causing delays or issues. Thank you very much.
I wanted to ask about one of the statements you made about having guidelines to inform the standards, and you mentioned geography, industry, some other factors. So I wondered if you were suggesting that there would be different guidelines based for different areas of the country, for different industries?
No, membership, Rob, is merely pointing out that there is no atypical election. They come in a vast majority of circumstances, and that the collective experience of all of those, large employers, small employers, geographic areas, the unique circumstances of whatever the proposed unit is, all accumulate to provide a body of experience. And that is embodied in the median time periods that have been reported, in my views. Not that we should be slicing it into sort of compartmentalized time periods.
Okay, I appreciate that. I was confused about that. And are you suggesting that in this rulemaking we provide the time periods?
Yes, I believe that to the extent that you have existing time periods, your work is done. There is no need to further, the time periods that show the collective experience, in my opinion, is the standard by which you should be implementing a as soon as practicable time period. I don't think anyone agrees that that is not optimal, all things being equal, that we get to an election as soon as practicable. But the question, the devil in the details, is, well, how much, in fact, will that time period be? And I would suggest that you already have some standards that you can use to inform that standard for practitioners and employees.
But wouldn't you imagine that there would be some challenges to creating static time periods, even if it varies from industry to industry, just because of the fluid nature of the circumstances that present themselves?
I think if you defined a rigid time period as the embodiment of as soon as practicable, I would completely agree with that, Chairman Pierce. But what I'm suggesting is that a median is just that. It is a guideline. It is a frame of reference. It is a time of period that the regional offices can take into account when they're trying to determine what works best in a particular circumstance. Recognizing that there's a vast number of variables that come into play in any election proceeding, it seems to me by giving them some benchmarks for them to be using as guides to try and work through some agreement with the parties is a workable solution, rather than, as you suggest, trying to statically say in every instant you shall conduct the election no later than X day. Again, I think there's just too many variables for you to try and establish minimum and maximums in these sort of circumstances.
Just to jump in then, are you talking, or would you be fine with us in defining practicable by throwing out a few things to look at for the regional directors to look at? Because I'm not quite sure whether you're approving that approach or disapproving that approach.
Well, I think to the extent that there are factors that lead to, in looking at the median time periods that already exist, if it's 3 to 4 weeks here, we'll be saying is sort of the normal time period. It seems to me that subject to whatever unique circumstances might apply in a particular case, setting that as sort of the timeline or the benchmark that they should be shooting for is not an unreasonable standard for them to employ.
Okay, so your premise is basically what's going on now in terms of the experience in the field is the baseline we should use.
Yes.
Okay.
And the median you're using is for non-litigated?
Well, again, I think there's a lot of moving pieces here. If we're talking about elections that ultimately have some contested issues, I think that the standard, the median time periods are slightly longer. Whether there is a middle ground there or whether there are going to be other changes to the rules that would require there to be some adjustment, I think depends on some of the other things that the board's considering adopting here.
Thank you, Mr. Torres.